My name is Nicholas Gordon and I'm the Managing Director of Evict Tenant. Evict Tenant's been established for 2.5 years. We're going from strength to strength and we specialise in evicting tenants throughout the UK. I have over 20 years experience within the letting industry, which gives me the knowledge and the understanding of what landlords and letting agents go through on a day-to-day basis. This also enables us to assist and understand exactly what they are going through. Not only are we here to provide assistance for evictions, but we also offer free advice for landlords and letting agents. We have an advice line, so simply give us a call with any question or query and we are here to help. One of the services we provide for our landlords is issuing formal demand letters. This is where your tenant is more than 3 days in arrears. We will send them a strong, firm letter outlining how much they owe, when they should pay, which is normally within 7 days, and also a strong warning of the implications if they fail to pay their rent. Failure to respond to this letter would mean that would lead on to what we'd call stage 1, which is service of notice. This process is very effective in order to prompt immediate action. We have found that 75% of tenants, once they receive this formal demand letter, do respond and pay their rent. Those that fail to do so means that we move on to the next stage, which is stage 1 of serving notice. So the two types of notices we serve are Section 8 and Section 21. Section 8 is based on rental arrears. There are a number of grounds which we can base the Section 8 on. The main ones are 8, 10 and 11, which is to do with rental arrears. Section 8, if the tenant is 2 months in arrears, or if they're persistently late. The other notice that can be served is a Section 21 notice. This informs a tenant that you require possession of your property at the end of a fixed term. The tenant must have been served with a deposit certificate, a prescribed information, terms and conditions of the deposit, and also a how to rent booklet. If any of these have not been done, then unfortunately a Section 21 will not be valid. Now, a number of tenants will take notice once they've received their Section 21 or Section 8 notice. Some may contact the landlord to ask for additional time. Again, that is down to the landlord. But you will have those that will ignore the notice. Therefore, that means we move on to stage 2. Stage 2 is where we make an application to the court for a hearing for possession. Once we make the application to the court, we normally receive a court hearing date in around 5 weeks' time. During that period, we will provide the court and serve all documents on the defendant. We will also serve all documents to the court, file witness statements and all supporting documents. On the day of the hearing, one of our legal team will be there to represent you throughout the whole process. Most tenants would heed what the judge's order requests. However, you will get a number of tenants that will dig their heels in and fail to move once that order has expired. If this is the case, then we move on to stage 3. This is where we instruct a county court bailiff or a high court bailiff to attend the property to remove the tenant from the premises. Or we can ask for permission to transfer up to the high court. The benefit of this is once we obtain a writ, which normally takes 2 to 3 days, we can have a high court bailiff at the door of your property within about 5 to 7 days. Obviously this will speed up the process, whereas in most cases the county court bailiff will take around about 4 to 6 weeks. One of our other services we provide is a tracing service. This is where if your tenant has absconded from the property, or if we've carried out an eviction and you wish to pursue any outstanding arrears, we can trace any person within the UK, which normally takes us around about 7 days, simply by providing us with the tenant's name, date of birth and previous address. Our systems, or the system we have in place, will enable us to track and trace them throughout the UK. If we haven't already obtained a judgment order, then we can make an application through the small claims for a county court judgment. This means that if the tenant owes you rent or has damaged your property, then by going through the small claims and obtaining a judgment order, that legalises the debt. Once we've got that judgment in place, we have a number of options in which we can recover that debt for you. Another process we use is what's called the accelerated procedure. This is where we make an application to the court for possession of your property. This is a more simplified application, which means we are simply asking the judge or the courts to give possession and possession only. Now, if your tenant is in arrears and we've served a Section 21 notice, in order to gain possession back, then we can also apply through the conventional route. This means that we will book a hearing, we will go through the process of serving all the documents to the court, and again we will represent you. The key benefit of this is that you will get possession of your property along with a judgment for the arrears and any costs. Again, if your deposit is registered within the schemes, we will request that the judge releases, or permission that the judge releases this deposit for. I always say time is the essence, so if you have a tenant that is causing an issue, give us a call now on 0121 472 0300, or call our head office on 0345 459 1830.